Hey guys, and welcome to the weekly Docket. This week we'll be looking at cases in Wisconsin, Florida, South Carolina, and Michigan. And we'll start in Michigan with the case of Ethan Crumbley's parents. This case involves a teenager who took a gun into school and killed 4 students and injured 6 more people, including a teacher. He pled guilty to his crimes, but his parents have also been charged with manslaughter. The prosecutors say the facts of this case are highly extraordinary and warrant the charges, which involve one's criminal level of negligence causing the death of another. But it's such an unusual situation that the Michigan Supreme Court has intervened and has heard the case on whether the facts, as the DA says they are, establish enough probable cause to hold the parents over for trial. This is an unusual intervention, obviously, to be at the state Supreme Court before the case really gets going. The issues here are 2. First, the concept of whether a legal duty is owed by the parents to the people at the school. The second, and the one I'll discuss, is causation. You need to cross 2 hurdles to show causation between the criminal negligence of the defendant and the injury suffered by the victim. The first is factual causation. Can you look at the facts and go, yeah, what they did, that was a big factor in this person getting hurt or killed or whatever. You got to be able to do that. Now, the court challenged the defense here that factual causation was obvious. The gun provided by the parents was used for the murders, and the parents, given what was known, should have prevented the use of that gun.
We'll grant you that you have to show factual cause and proximate cause. I think factual cause, at least in a probable cause standard, is not even worth discussing today. But
defense countered this to some degree, saying that, hey, well, yeah, you can find factual causation. In fact, you could say if they had never gotten together and the mother hadn't gotten pregnant and the child hadn't been born, he wouldn't have shot anybody. So you can always go back and find factual causation. In a lot of these cases, that's not the end of the story. Plus, they disputed the parents knew he was a danger to others. But as the court points out, the Supreme Court review is supposed to be just abuse of discretion by the trial judge at this level, at this early stage of the case. So if the facts are at this point either clearly in favor of factual causation or even arguable, the trial judge's decision to bind the parents over for trial would be upheld. And this is a loser for the defense. The second point on causation, well, that's where the argument really is. That's called proximate cause. That's the idea that the law will set limits on the responsibility one has for negligence based on the chain of events. Sometimes that's discussed as reasonable foreseeability. Let's look at the old case that kind of set it in motion in terms of teaching generations of lawyers how this is supposed to work. There was a woman who was delayed from returning home by a train company by conductor negligence. They didn't stop where she was supposed to get off. They went past it, so they couldn't get her to her home that night. The train company accepted that and got her a hotel room so she could catch the train home in the morning. Well, while she's sleeping in the hotel room, she says a kerosene lamp exploded and she was injured trying to put the fire out. She sued the train company saying, hey, if you hadn't delayed me, I wouldn't have been in that hotel room where the lamp blew up. The court decided for the train company. Yeah, it's true what she said. She wouldn't have been in that hotel room or even in that city but for the train company's delay. But the court said, hey, look, train company can't reasonably foresee that any negligence they had on not letting you off at the right stop would result in you getting hurt by a gas lamp exploding in a hotel room in the middle of the night. And the court said, look, if there's negligence here, that's on the part of the hotel people. So that's the idea. Associated with that concept is the idea of what's called a superseding cause. That's something that happens between your negligence and the injury that supersedes or breaks the chain. So a general rule, but it's not universal, is that if a third party comes in the middle of this and acts intentionally to cause the final injury, the negligent person would not have foreseen that. And because the teen here intentionally plotted and conducted the murders, it's his acts that caused the injury, and the chain can't go back to hold the parents criminally responsible for their negligence. So the DA argued in this case the parents knew or should have known he was contemplating taking the gun to school. This intentional act wasn't something they couldn't foresee. And so this is not an ordinary case of an intentional act breaking the chain. So obviously, I think this case turns on whether the court will find a general rule applicable here or some exception narrowly applies. As they stated multiple times, they're concerned that allowing criminal responsibility here might open a door to parents and others being responsible for anything bad a child, teen, or whatever might do.
I think it is a valid concern about the precedent that this will establish, because we know lawyers who are smart and crafty will use this case to argue something down the future that is not as compelling and lead to issues that you mentioned about criminal responsibility for the intentional acts of their children.
So we'll have to see whether the court allows this case to go forward. And if it does, well, the facts look pretty bad for the parents. Now, some draw parallels between this case and the case of Darrell Brooks' mother, giving him the SUV, knowing he was a danger with it. I get it. I'm very sympathetic to that point of view. For the issue of legal causation, though, I don't think the case is strong, but I get it. What is interesting is Wisconsin does not use the same legal framework for proximate cause as Michigan, and from cases I saw, they don't give as much weight to excusing negligence just because a third-party act was intentional. So if a DA did want to charge Brooks' mom, that could be significant, but it doesn't look like that will happen. Brooks has status hearings for his cases next week. He's got 3 sets of cases, 2 of which are joined. I did see an order to produce on the docket, and that usually involves a prisoner moving. So it looks like they're planning on having this hearing. If the cases aren't resolved in some way, the judge will need to consider defense counsel motions to withdraw, which apparently arise from Brooks' declaration he wants to represent himself, and the judges will have to go through that as well. Remember, generally speaking, he has a right to represent himself. It can't be taken away lightly, so hold on for that. An interesting situation in South Carolina in the Murdaugh case, and another example of how truth is not always the top priority of the criminal justice system, or the justice system at all. There's a surprisingly pro-criminal statute in South Carolina that matters for this case. Alec Murdaugh pled not guilty in all of his cases, including the financial crime cases. But in his murder case, he took the stand and essentially admitted to stealing millions of dollars from many people. Wow, he's finally owning up to what he did. Case closed, right? On the financial crimes. Not in South Carolina, which has this surprising statute. The testimony of a defendant in a criminal case shall not be afterwards used against the defendant in any other criminal case, except upon an indictment for perjury. Okay, so he can admit to the financial crimes in his murder trial, trying to make it look like he was owning up to things for the jury, and then continue to pretend he's not guilty in the other cases with no fear of the statements he made in the murder case being used against him. It's just weird. Last week, I mentioned the case of Russell Lafitte, who was convicted in federal court for financial misconduct stemming from interactions with Murdaugh. I mentioned his motion to set aside the verdict, which the court shot down, and that included the concept of how long the jury deliberated. Well, he's back now saying the verdict should be thrown out since Murdaugh said in his murder trial that Lafitte was innocent and that Murdaugh did all the financial crimes alone. Who wants to make a bet on how that turns out? Yeah, let's throw your case out because the world's biggest liar ever said you're innocent and did it while, because of this weird statute, he's got a free pass to say whatever he wants. Yeah, no. Other people who helped Murdaugh also should be sweating some, even though the southern humid heat hasn't hit us yet. SLED says they'll go after anyone who participated in his crimes, and the rumors of grand jury activity are pretty solid. In Florida, back to the Sarah Boone case, the court has noticed a pretrial conference for the end of March, which was the plan. I've not seen an order allowing fees for the mitigation expert we talked about last week, the defense has requested. With a trial set for less than 2 weeks after the hearing, April 10th, I wouldn't be surprised to see another delay requested by defense if they're trying to work up facts for any claim that attempts to justify what she did or at least mitigate it. Let's close it out back in Wisconsin with the Zechariah Anderson case involving the charge of murder, but the body never found. This case continues to be unusual. Lots of weird things have happened in it so far. This week involved allegations the parents were trying to influence the testimony of their daughter. Defense said the mother was using sign language from the gallery. Prosecution said the defendant was doing similar things. What do you think is going on in this video? Well, when things got difficult for the minor, which is understandable, the judge asked, "Hey, are there any lawyers in the hallway? Go get one." He then asked the lawyer if he would do the judge a solid and represent the minor. The lawyer said, yes, of course, and helped out.
Would you do me the favor of taking on this lady as a client?
I certainly would.
All right. I'm going to appoint this man.
The count of unusual things in this case is getting pretty high, but also the circumstantial evidence is stacking up as well, even though defense has given it their best shot. Well, that's it for this week. Thanks. Bye.